The schedule of distribution and payment of claims. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine Scale Form PC 596. Scale for State Court Administrative Order, PC for Probate Court, 596 is the form number, and you're welcome to contact our office. We'll be happy to provide this form free of charge to you. With all of the scale forms, they are created by statutes and court rules that give rise to the form itself. And in this particular one, you'll see by the floating yellow arrow that there are two statutes, 700.3952 and 700.3953. And these statutes apply to probate administration, in which during the administration you're coming to the close and it's time to distribute, to close out the probate estate. The statutes provide that the petition for complete estate settlement, a form that is covered in a separate video, as well as a final account and the schedule can all be filed together, but can't be done so before the creditor period has expired. So this is really one of the final steps to the distribution of a deceased probate estate. So imagine you're asking the court in a petition for complete estate settlement to determine that all of the duties and responsibilities relative to the personal representative have been completed, that the attorney fees and costs should be approved, and that the schedule as set forth here in the schedule of distribution should be allowed. It will also potentially adjudicate testacy, meaning if there's a will or no will, as well as a determination of heirs. So this is part of this closing packet. Now, the schedule of distribution and payment of claims is not a required form. It's not required when you file a petition for complete estate settlement, nor is it required in an informal closing with a sworn closing statement. But generally, we see this package of documents being filed collectively: the petition for complete estate settlement, the final account, as well as the schedule of distribution and payment of claims. So let's work our way through this document to understand what it means, how it's generally completed. With all of these forms, we strongly urge you to work with a skilled, competent probate practitioner, a lawyer who understands how these forms work, when to file them, how to file them. It's really important that you do this correctly, because as part of your responsibilities as personal representative, you have a duty to accurately report this information to the interested persons in the estate as well as to the court. In the top left corner, you identify the county in which the probate matter is proceeding. In the top right corner, the file number, the case number. And as you can see from the rectangle, it is the schedule of distribution and payment of claims. The top section identifies the name of the estate and that you as personal representative are completing that form. Now, there are various checkboxes here, and depending on the circumstances, you're going to check them. So you have to understand, in this particular case, have these claims been presented and paid or settled or disposed of? Or are you suggesting that they're going to be paid upon approval of the court? So here you can identify creditors. Now, often during the administration, the creditors are being paid during the course of the administration. In this particular case, you are going to identify whether they have presented claims and have not been paid, settled, or disposed of. And if approved by the court, these claims will be paid. Now remember, in the probate distribution process, there is a pecking order when there are insufficient assets to pay creditor claims, as well as the distributions and exemptions and allowances and funeral expenses and so on. So here, this is addressing that pecking order of payment. So here you'd identify the creditor, the amount of the debt, and the amount to be paid. So for example, if you're paying less than 100 cents on the dollar, the amount of the debt is going to be different than the amount to be paid. And again, the statute differentiates between different types of creditors, as well as whether you pay them pro rata or not. So again, very nuanced. It's really important that you understand the statute to understand how to complete this particular section of this particular form. As you move further down, there are distribution to devisees that have been made. So this checkbox for number 3 are going to identify the assets, the value as set forth in the asset, the date of the distribution, and who is entitled to receive them. Now those people may be heirs, meaning if there's no will, or they may be devisees in the context of a testate estate when there is a will. So again, you're identifying that these distributions have already been made. Not they're going to be made, they've already been made. The next section addresses the attorney fees and fiduciary fees. Remember that a personal representative can charge a fiduciary fee as well as retain counsel, and this is where you identify the fees and costs that will be paid before distribution. Then the next section is you're asking, if approved by the court, that the remainder will then be distributed as set forth. So often this is the residue clause of a will. The remainder after specific distributions are set forth. Again, this form has to really be understood and read in context with not only the statutes that are in the bottom right corner, but with the statutes that identify how you pay creditor claims, as well as exemptions and allowances, as well as the distribution of assets. It's very important that you understand holistically how all these statutes work together before completing the form, because you don't want to distribute incorrectly and get alleged that you failed to administer and distribute appropriately. So again, you identify the amounts and even the issue about how you value an asset. Are you using an appraised value? Are you using 2 times the state equalized value? Did you just pick a value off the top of your head? How you make those decisions are really critical to completing this form. A lot going on here. This form should be done with great care and with great forethought. The bottom right corner is for the petitioner, the personal representative who is filing this, their signature and their relevant information, and then the attorney's signature. And with all of these scale forms, you're always doing them under the penalties of perjury, so they have to be signed with the best of your information, knowledge, and belief. And again, you're setting forth a plan of distribution, the schedule that you're asking the court to distribute and to allow for the payment of the claims. Again, complicated, not an easy form to fill out. Do so cautiously. Read the statutes, read the court rule, read the statutes that relate to the various aspects of this particular form to understand how you complete it and to be assured that you're doing so correctly, because you're going to be filing this with the court and then serving it upon the interested persons with that petition for complete estate settlement. Again, I strongly urge you, before embarking on this form, work with a skilled, competent probate lawyer. At the Probate Pro, we're passionate about everything probate. If you have questions about the schedule or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.